Lord's side. Praying on the Lord's side. Which side are you standing on? Standing on the Lord's side. I stand, I stand, I stand, I stand. Standing on the Lord's side. I stand, I stand, I stand, I stand. Standing on the Lord's side. Okay, so let us I'm hearing this is my story, this is my song. So let us find that one. This is my story, this is my song. What is the first line of that one again?
Blessed assurance.
Blessed assurance. Okay, blessed assurance. Okay, let's sing blessed assurance.
416, 416,
416. Okay, 462. Okay. All right. Let's go. 3, 4. Blessed assurance, Jesus is mine. Oh, what a foretaste of glory divine, heir of salvation, purchase of God, born of His Spirit, washed in His blood. This is my story, this is my song, praising my Savior all the day long. This is my story, this is my song, praising my Savior all the day long. Perfect submission. Perfect submission. Perfect delight. Visions of rapture now rest on my side. Angels descending, bring from above echoes of mercy, whispers of love. This is my story, this is my song, praising my Savior all the day long. This is my story, this is my song, praising my Savior all the day long. Perfect submission, all is at rest. I in my Savior, I'm happy and blessed. Watching and waiting, looking above, feeling His goodness, lost in His love. This is my story, this is my song, praising my Savior all the day long. This is my story, this is my song, praising my Savior. Right? So at the end of our time, we know that we will be expected to give an accounting. We'll be given an accounting of how we take care of our bodies, how we take care of our life, how we take care of others. But one of the things that God has given us, we also have to make an accounting of that. So this afternoon, right, this afternoon, we have someone here who will be presenting to us. Pardon? You want to wait until everybody comes back?
We're gonna go over it again.
Okay.
We're just going to drop off something and come back. Somebody feel to come back.
I think we should proceed though, Sister Joyce, because we have an invited guest. We have to respect his time. Right? We have to respect his time. So we will this evening, right, as we go on, let me tell you, our presenter is Jeffrey St. Clair. Right? He is familiar to me because he is the husband of my cousin, right, Kathleen, and the two of them just walked in. Kathleen, I have to say, you make me drop because I thought it was Auntie Esme coming through the door, I said, how's she looking so young, Auntie Esme, But yeah, it's a pleasure to see you. I am so happy that you have accepted our invitation, right, to come and speak to us, right. Jeffrey has his own firm, right. He is a part of St. Clair and Associates, right. He would make a better job of introducing himself, I'm sure. I'm kind of awkward at these things, right. I want to prevail on his wife for a moment to introduce him if she would. It's a man you know, my dear. So do introduce him. Thank you.
Good afternoon, Liberty, right? Yeah. Good afternoon. I am being put on the spot, so I have to tell you about my husband, okay? He loves the Lord, and he is humbled by what God has blessed him with, and desires to share it with others. And that is what I appreciate about him. He's great at his job, and he does it to the best of his ability, so that to the point that every morning that he leaves the house, I pray with him that he does the best for each client that walks through his office door. When his office was being formed, when he moved into, and then when he moved from one office to the next, we went into that office and blessed it and prayed that everyone that walks in is treated as like they are a child of God. And so that's something that, a value that we share is that myself and him, whatever God has given to us, whatever God has blessed us with, that we are able to share with others and do the best that we can. And we have seen, and we don't do it just because we want to be blessed, but we do it because we love what we do, and we love God, and God has favored us by returning blessings to us. I have on my Invisalign, so it's like hard for me to speak, so sorry about that, okay? I'm getting used to it. But that's who my husband is. He's been an attorney for over 30-something years. He has his own business. He deals with wills, trust, and estates, and he will share with you, being a better steward of the gifts that God has given to you throughout your lifetime and what to do with it. as you die. It's not me say that word, but when you die, what will be left? What you have left behind, and how it can be utilized. Okay, so Mr. Sinclair, the floor is yours.
But she never stopped.
It wasn't long.
It was long.
It wasn't long.
Welcome to my world. No, I'm kidding. Anyway, thanks, babe, and thank you for having me here. It's an honor, and I don't take this lightly. It's an honor to be asked to speak to anyone. So I really appreciate the opportunity, and it's a privilege. It's a privilege and an honor. One of the things that that happened to me at a very young age is it was my first real, since my wife talked about my love of God, it was my first real connection to God. And I was not I mean, my mother sent us to church and all of that, but I was not a godly kid. You know, I said, now I lay me down to sleep, and, you know, breakfast, you know, you pray before meals, but it was mechanical. It had no emotion, no feeling tied to it. And I think I was probably about 18 or 19. And a friend of mine asked me to be the godson of a child, which, you know, I agreed. I don't even know the boy's name to this day. It was so long ago. But we went into a church to christen him. It was a Catholic church. And I was always a card, you know, a wise guy. And I never forget, when I walked into the church, I felt a compulsion, like I never felt, to go sit in the pews and start praying. And because everybody knew I was a wise guy, they thought I was fooling around. They said, come on, man, stop playing around. This is not the place to play. But I remember that day like it was yesterday. And I begged God to allow me to go forward with my dream of becoming an attorney. And I promised him that if I was able to achieve that objective, I would always be prepared to give back as much as I could. And I take that commitment very, very, very seriously. Very seriously. For the last 20 years, I've been going to an organization and donating my time. I don't do things free, but I bear in mind for people who can't always pay the full price. I bear in mind for people who simply can't pay sometimes. You know, I did a presentation at a church one time, and it was so funny. I talked to the lady, and, you know, I was going over everything she needed to do, and I was saying, and the fee is, she said, oh, I'm not gonna pay you. And she was so cute about it. What am I saying? Grab her by the throat and shake the money out of her. So, you know, sometimes those things happen, and you know what? It's a blessing to be able to provide any help to anyone who needs it. At the outset, I always like to say, what I'm going to discuss today is information only. It's not necessarily legal advice, even though I'm an attorney. I'm capable and qualified to give this advice. I urge you to take it as information only and utilize it towards you going forward. And if you do decide you wanted to do some estate planning or something, to meet with me or a qualified attorney. It doesn't have to be me. There are tons of qualified attorneys, but for the same token, there are tons of unqualified attorneys. It's just like any relationship in life. There's good and bad in everything. And I've seen clients come to me after a loved one has passed with a trust or a will. That is a disaster, because the attorney didn't really do that, or because he just took it lightly, or because he didn't seriously approach, you know, the task. And what happened is, it makes it that much difficult. And, you know, I take it very seriously, because this is a person's last wish. They're not there to discuss it or enforce it. So when somebody tells me this is something they need done or want done, or they don't want this one to get that, or they want this one to get something else, I take it very seriously, and I try to structure any documents I create to ensure that their wishes are carried out with the least stress available. So I'm going to talk about, there's 5 major estate planning documents. We've heard last will and testament. There's a trust, There's healthcare proxy, living will, and the power of attorney. Those 5 documents, or sometimes just 4, comprise, to me, meaningful estate plan. Because what happens is, I know lawyers that separate it, and they'll do a la carte. They'll do a will, but they won't do a power of attorney. They'll do a power of attorney, but they won't. And I don't think that's proper, in my opinion. Again, you know, I can't question what other people do or other people accept. But in my opinion, without giving somebody the full package, you're not really preparing them. Sometimes I give clients, when I do their will, they say, I don't want that. I say, you know what? You don't have to execute it, but I'm going to give it to you anyway, and I'm going to explain it to you, and you think about it in the future about whether or not you want to execute it, because it's important, particularly the advanced directives. The advanced directives are the 3 documents I called the power of attorney, living will, and the healthcare proxy. Those are important because during your lifetime, they help people make decisions for you. They help you to have your life. So the power of attorney, for example, is a very, very, very powerful document. And I always urge people that if you're going to have someone act as your agent under the power of attorney, you have to make sure it's somebody you have confidence and some level of trust in. You don't want to give it to somebody you say, well, you know, he's okay. No. And we always say, as lawyers, we say, if you got to think about it, or if you're hesitant about it, then don't do it. I used to work with inmates in Rikers Island, and they would come to me frequently to notarize a power of attorney, and they would say, I would say, well, who's your agent? Because the principal is the person granting the power. The agent is the person who's going to act on that power. I would always say, who's the person you want to, oh, it's my wife, oh, it's my mother, oh, it's my sister. And I would ask them point blank, do you trust that person? That's my wife. What are you talking about? That's my mother. I said, I didn't ask you that. I said, do you trust that person to be able to respect your wishes and to be honest and forthcoming with you? Because it's important. And they would invariably say yes, but at the same time, you know, sometimes people hesitate and they think about it. You know, oh, it's my girlfriend. I don't know about your girlfriend so much. So it grants probably 15 to 16 different powers that you can authorize a person to act on. And it works in the event that you're either incapacitated or sometimes just unavailable. You could be traveling out of the country or out of the state and you need something done at your house, a boiler repair, or, you know, a tenant's acting up, or you need somebody to collect rent or pay a bill for you. The power of attorney puts that person in a position to be able to carry out those efforts for you without any stress. And so it puts that there. The value of it also is if you somehow do become incapacitated, you know, due to age or injury or some type of infirmary, it's very, very important to have that in place. Because if you don't, what happens is the person who your loved ones, while they may be your mother, your spouse, your children, they don't always have the authority to act over your person and property. Even though you think they should, legally, under the eyes of the law, they may not be able to do that. And the state can step in and take over that ability. And I've seen it happen. It's not a pretty sight, but I've seen it done. So the power of attorney saves you the trouble of, at some point, getting what we call in law the Article 81 guardianship. The Article 81 guardianship is where you go to court and you have to get a judge to grant you the right to be the guardian over your wife, over your son, over your mother, which you should have automatically, but not in the eyes of the law. Just try going to the bank and making a withdrawal from your mother's account without having a power of attorney unless you're on the account. The bank's gonna stop you right at the door. No, sorry, where is she? She has to sign. And partly that's because there's so much wickedness in this world, so much fraud. They have to be ultra vigilant in terms of doing anything, you know, to make sure people get stuff. So and to get an Article 81 guardianship, it's going to cost you probably around $15,000, $20,000 to get a lawyer to process that for you, without exaggeration. I remember it used to be $10,000 when I first started out, but now it's much, much more because it's work involved. Whereas a power of attorney is a couple of $100. So even if you don't want it or need it, get it, because eventually it could save your family some definite headaches. in conjunction to the power of attorney is a healthcare proxy. The healthcare proxy also appoints someone as an agent to act on your behalf. The distinction between the healthcare proxy and the power of attorney is the healthcare proxy deals only with medical needs. If you've ever had surgery or gone into the hospital for an extensive stay, there's a good chance one of the many documents you signed was a healthcare proxy prior to you getting the operation. So the healthcare proxy basically puts someone in a position to inquire with the doctors what's going on, how they doing, what's the prognosis, what's the diagnosis. I also give the healthcare proxy in conjunction with a HIPAA release, just in case some doctors are reluctant. And doctors are the same way. They're concerned about liability because this is a litigious society and people want to always sue them. Oh, you broke my privacy. You know, they're just trying to do a job. So the healthcare proxy is very important as well. The difference, the power of attorney does not deal with any health-related issues. It deals mostly with business, finance, those type of issues. The only health-related item on the power of attorney is paying your medical bills. That's the only health-related item. So it's important to have those. And the third advance directive is called the living will, a name that I really don't like, but that's what it's called because it's confusing. People hear will and they think it's like the last will and testament, and it's totally not. It's totally different. This one is effective during your lifetime. And unlike the power of attorney and the healthcare proxy, it's an outline of how you want to be treated in the event that you're incapacitated. So if you want no DNR, you know, do not resuscitate, you want withhold hydration, if you want everything humanly possible done, it gives you that option to do that. And typically most people say, you know, work on me for a while and then, you know, leave it in God's hands. You know, I mean, that's what mine says. I don't really want to, you know, linger. And, you know, knowing my wife, if I'm taking a long nap, she's going to say, pull the plug.
Time to wake up.
Yeah. But no, I'm just kidding. But, you know, I went through that with my mother, and it's a real hardship. It's a real hardship on the family. I know it was, and it's not an easy decision to make. And doctors don't like to make it. So you have to be able to make it easy for them by putting someone in a position to understand what your concerns are. In fact, when we decided that we were going to stop, you know, the extraordinary measures on my mother, we had to meet with a committee of doctors. And they wouldn't do it. It was 5 doctors, and 5 of them was like, I'm not doing it. I'm not doing it. One Indian brother said, listen, if this is what you guys really want, I'll facilitate it for you. And 1 out of 5, because it's against their training. Their training is to do everything. But sometimes that's not in the best interest of the person. You never know. You hear about people coming out of comas after 10 months, you know, years later. You never know. But sometimes it's really clear that no matter what, it's not going to make a difference. And particularly with my mother, it was a difficult decision, but it was one that had to be made. I mean, you know, and it wasn't a selfish decision in that we were like, oh, it's killing us. It wasn't that. It was just like, just watching her dwindle away is something I pray no one has to ever go through. You know, and if you've gone through it, you know what I mean. So those are the 3 advance directives: healthcare proxy, living will, power of attorney. The next document is the last will and testament. That's the document that determines where your stuff goes when you pass. It's effective only when you pass. It's revocable during your lifetime. And I always like to ask, does anyone here have an estate plan in place? Show of hands. Okay, I'm gonna give you a little surprise. You all have an estate plan in place, because if you don't have one that you determined you want, then the government's gonna impose one on you. So when you go, if you got a child that you don't necessarily think should get equally what you were entitled to, if you got an ex-husband that you ain't seen in 20 years, but you still legally married, you're gonna have some problems. You're gonna have some problems. I once represented a woman who was separated from her husband for 40 years. She hadn't seen or spoken to this man in 40 years. When he died, she still got a part of his estate, much to his new family's, you know, hey, they were pissed. Yes, sir.
The relative, sure.
Yeah, always. But, you know, I mean, the circumstances of which she left that house were horrendous.
and she left for her own protection. And I respected her. She was virtually kicked out the house in her nightgown, when he came home drunk one night, and she never turned back, which I was like, wow. I said, you never went back? You never? She says, no, he knew where I was. I was with my older daughter, and if he wanted to contact me, he would have, but he never did. And she was like, I never wanted to speak to him again. And in his will, he says, I am married to XYZ. So the family really, while they didn't like it, there was nothing they could do about it, because the spouse has what's called a right of election. So if the will didn't leave a surviving spouse something, then that surviving spouse has a right to elect against the will, and they're entitled to the first $50,000 plus 1/3 of the net estate. So in New York State, you can disinherit anybody you like, but your spouse. So I don't have to leave my kids, my cousins, my friends, my relatives, one single penny, but I can't disinherit this woman, because she'll be able to go against, she'll be able to challenge the will. And that's an important provision, because it's kind of a gender-specific provision, because in the old days, men would leave their older wives that they've been with for 20 years and go with some younger tart, and all of a sudden, she gets everything. And the wife is like, I stood by this man for 20 years, I raised his family, and now this one's... So they put that provision in place to protect the surviving spouse. It can go both ways, man and women. You can't disinherit your husband either, so get that out your head as well. And in situations, I had a client come to me once. He married somebody for citizenship, and he didn't know where they were or whatever. And I said, yo, dude, they're going to be able to collect against your estate, and you got a bunch of kids. So I would advise you to figure out something. And I gave him the forms, and he was able to find the woman, and she signed it, because she didn't care about him anymore either. And he got a divorce. So when he passed, she had no interest in his estate. So it's very important to do that. As I said before, if you don't have one in place, then the government's going to definitely get you one. So, like I said, the last will and testament has to be executed by someone over the 18, has to be signed by an adult, which over the 18, has to have, at least in New York State, 2 witnesses. Doesn't have to be notarized. There's a part of the will package that gets notarized. It's called the subscribing affidavit. That gets notarized, and that's where the witnesses testify that the person signing the will was coherent, was of clear mind, and understood what we call the nature and objects of their bounty, which basically means they knew who their children were, they knew who their family was, and they knew what their assets were. So once a person is able to establish that, then they're deemed coherent, the witnesses sign off. Now, the level of competency for a will is far, far lower than a contract. A person could be crazy as a bat, 360 days a year. But on the day that they execute their will, if they present coherently, logically, and intelligently, that will is valid. So a lot of times people don't understand that. It's very important, because sometimes you have people. I had a woman that was she was dying from cancer, and every time I went there, she was drugged up. And I spoke to the doctor. The doctor said, if you get here before 9 o'clock, she's clear as a bell. And that's what I did. I got there before 9 o'clock. I brought my own witnesses. I brought my own notary. I spoke to the lady. She was very, very clear. She was adamant about what she wanted done. She didn't have a big family, and she didn't have a spouse. It was mostly her brother and a sister. And she was like, this is what I want done. And it was amazing, night and day. And after I spoke with her, I stood around and we were chit-chatting, and I could see the drugs were taking effect. And she started fading, and it was kind of painful to see, but I was glad I was able to help her. So the will basically designates who you want to get your stuff, and it also it could appoint 2 different persons. It has to appoint an executor. The executor is charged with taking out, with exercising or carrying out. You want me to play the drum? Oh, okay. The executor is charged with carrying out the wishes in the will. So that's the person that you feel comfortable with saying, this is what my person wanted, my husband, my spouse, my friend, this is what they wanted. It may involve selling property, it may involve transferring stuff, whatever the case may be, that person is charged with that responsibility. Yes, sir.
Now, you can have two executors, you said?
Yes, you can.
What
Well,
if they disagree?
that's a good point. I don't like to have co-executors in my wills. If the person insists on it, I will do it. But I would prefer to have an executor and an alternate in case that person can't serve. A lot of times people I had one woman, she had 3 kids. Well, I want my kids. I said, listen, no offense to you, ma'am, but naming your 3 kids as executors is a nightmare waiting to happen. I say, pick the one that has the most business savvy, that you feel most comfortable with, and let them be the primary and let the other 2 be alternates just in case. As I said again, if a person insists on it, I'll do it. I had another woman that came, she only had 2 kids, and she wanted both kids to be named. I didn't think that was as difficult, but to get 3 people to agree on something sometimes, we've all been to business meetings. Sometimes it can be a tumultuous experience. And particularly, as you said, the vultures come out and everybody's seeing dollar signs. So I typically prefer to have one primary and an alternate executor in the will. There's 3 ways property pass in a will. So there's a specific gift, there's a general gift, and there's what we call a residuary. Let me back up for a minute. I said there's 2 possible people you appoint in a will. The second person you can appoint in a will is a guardian. If you have minor children, you can designate who you want that guardian to those children to be in your will. And it's often respected by the courts, but it's not mandatory that they do so. So that guardian still has to establish himself as reliable and worthy in the eyes of the law. So you can appoint an executor and a guardian only if you have minor children. So as I was saying, a specific gift is, I have a watch my father left me. I'm gonna probably leave it for my older son. I leave my father's gold watch to my son Quay, blah, blah, blah. If for some reason, and I've been trying to sell it for the last year, I just haven't had it offer I like. If for some reason I'm able to sell that watch and I haven't changed my will, he takes nothing in terms of the will, in terms of the watch. If I don't sell it, he can take it. But if the other way that you can give specific property is I leave $10,000 to my son Quay from my Chase bank account ending 1234. Same thing. As long as that $10,000 or more is in that bank account, he'll get it. If it's only $4,000 in the bank account, he can only get 4. If there's nothing in that bank account, that's what he gets, nothing. So those are specific gifts designated to a specific person from a specific location. So those things are very particular. So it could be your wedding ring, could be a pair of earrings. I had an aunt that I did her will. She had a piece of furniture she wanted her sister-in-law to get. Specific item to a particular person. The other one is what's called a general gift. Same thing. I leave $10,000 to my son Quay, period, without any designation of where that money's going to come from. In this regard, the money can come from anywhere. It can come from my retirement. It can come from a life insurance policy. It could come from the sale of my house, whatever the case may be. He would get that $10,000 from any resource. So that's a general gift. It's to a particular person, but it's not from a particular resource. And the third section, the third way of giving is, which every will has, and some wills are just strictly a residuary will, is everything I own, whether real or personal property, wherever it's located, goes to A, B, and C. And particularly that's important when people have property out of the country or out of the state. Typically when I do a will in New York State, I don't name property that you have in another country or another state, because New York won't recognize it, they won't have authority over it, but it could increase your tax basis, or it could increase your fees that you have to pay the courts to probate the will. So I always leave those things out. I explain to the person what they have to do in the event the person passes, how they got to go about it. Typically, you have to go to that place and work it out in that location. So I don't need, some people say, I want everything. Again, when people come to me for advice to do stuff, if I'm representing you, just because you want it is not what I'm going to do. because if I think it's against your estate plan, I'm going to be very clear to you that this is not in your best interest. Once again, if they insist, I will do it, but in my notes, I will put, against my advice, this person insisted that I do this, that, and the other. Because what's going to happen is down the line, somebody's going to question it, and I want to make sure that it's clear that this is what they wanted. Typically, it doesn't cause a problem, but it's really my objective in doing someone's will is to make sure it gets processed as quickly and as easily as possible. And in my experience, I don't want to say anything bad about the courts, but they are used to seeing what they're used to seeing.
Yeah.
They are not creative people. And believe me when I tell you, lawyers, we are not creative people either. I've been doing the same will basically for the last 20 years, and I have no problems with it. We're not here to reinvent the wheel and try to be cute and flamboyant. No, we don't need that. You don't need that when you're gone. So we try to keep it as consistent. With the clerk look at it and say, oh yeah, I recognize this language, and they turn to the next, because they go over every page. Oh yeah, I recognize that. Oh yeah, this makes sense to me. I don't want it to be any problems down the line with getting that will authorized.
Question.
Yes, sir.
Sometimes we get the impression that there is so much entailed in preparing a will that discourages folks from preparing a will.
Mm-hmm.
I remember sometimes folks tell me that I gotta know everything that I want to do, and I gotta list everything down, and sometimes it seems so tedious that folks say, you know what, it doesn't make sense in that. So is there an easier way or what?
I used to give people a questionnaire, and that questionnaire had your 401k, stocks and bonds, property out of, and it was like an 8-page thing, and people would be like, I don't have all of this, and I would get the same response. It doesn't. That thing is twofold. One, we don't realize how much stuff we really have. You start taking an accounting, if you own a home, you own a car, you might have some jewelry, you have a retirement fund. You'd be surprised. I was talking to a lady just yesterday, and she was like, oh, I don't really have nothing. I said, you own a home? Yeah. I said, you've been working on your job? Yeah, I've been working 30 years. I said, you got a pension coming, right? Yeah. You got any jewelry? Well, I got some jewelry I bought when I was young. Right then and there, she probably had close to $1 million without even realizing it. We have more stuff than we realize, and we want to make sure it goes where we want. So I don't do that in my practice. I sit down with the person and I find out what their concerns are. You don't have to list everything. As I said before, the residuary clause is going to make sure that stuff goes where you want it to go. So sometimes lawyers, I know a firm, they send me some of their business because people don't want to pay their exorbitant fees. They charge $600 an hour, and their average will is over $10,000. Now, this is only really rich people are going to do that. But what they do is they interview everybody for 3 or 4 times, more than I think is necessary. They create this questionnaire. They have this really fancy ribbon cutting ceremony to execute the will. It's a whole rigmarole they go to make that seem justified. And, a couple of staples and a handshake, it's really done. So the people come to me and they say, oh, they want to charge me 10 grand. I said, I'm not going to charge you anywhere near that. I'll charge you 8 grand. No, I'm only kidding. Nowhere near that. Because, like I said, they're capitalizing on people who have the disposable income, and that's not a big deal to them. And they also have to feel like they're getting the best service. I have a late model BMW. And when I go to the dealership, it's so much nicer than when I drove a Ford. They give you coffee, and it's a nice couches, and they got the Wi-Fi, and they got TVs, and they got couches. When I had the Ford, it was just like a bench, because they want you to feel like you're paying for more, And I see people coming there with some really expensive cars, and mine is, like I said, 9 years old, and I'm just as proud of it as they are. But I go in there, I make sure they always have these these little water bottles. I say, you don't mind if I take a few of these? And I take a few of the waters. I make sure I drink some tea and everything. I take advantage of it. You know, sometimes they give you breakfast, and I exploit all that because, you know, they want my business.
I'm gonna get one of those.
It's so much nicer. But at the same time, if you're not cautious, you don't have a warranty, you're going to pay for all of that. They will make sure they're not giving it to you for nothing. You know, they will make sure, just like when you go to those big firms, they might have all kind of amenities available. But, you know, at my office, the best you're going to get is a glass of water or a cup of tea. And, you know.
I have another question.
Yes, sir.
And
I love questions, by the way.
this is a situation that is real.
Mm-hmm.
There was no will. The person died and has property here in the U.S. and in a foreign country.
Mm-hmm.
And our sibling, I guess, to do anything in the other country, we gotta have attorneys from there
Typically.
to deal with. Okay.
I mean, you don't, it's just like anything else. There are some things people can do for themselves if they have the will to do it. You know, you could conceivably draft your own will. You could conceivably represent